Hi, everyone. I'm Kimbyrleigha, and this is Kimbyrleigha Live, where I discuss current and ongoing true crime cases and break down legal aspects in easy to understand manner while I brush up on the law for my upcoming bar exam. It gives me an opportunity to also have an outlet because YouTube is a lonely job and I love talking to all of you. That's why I go live. And if you're new here, hi, it's nice to finally meet you. I do have a main true crime channel here on YouTube, and we're almost about to hit 500,000 subscribers. Crazy. I feel like we have to do something really special for it, but thank you to all of you. And also, I have a true crime podcast with my husband called Dark Livity. And guess what? I remember to link them both in the description box this time. Those are what am I saying? Those discuss solved cases in a narrative manner and they're edited. So you won't get any mistakes like me mispronouncing things and slipping over my words. But if you like that kind of thing, check it out. They are in the description box. I'm also happy to announce we had an internet overhaul today. That's why I'm a couple days behind because we have all of this new stuff here. I'm actually in a whole new setup where it's like Ethernet cables and it can stream better. And we're going to prepare a lot of fun things next week. It's going to be entirely different on this live for the better. So, a more awesome experience for all of you. You're going to be able to see all of the little emojis on the screen. You're going to be able to see everything, which is going to be fun. So I think I'm going to use a different system, which we're testing out this weekend. But anyway, hopefully I've taken care of the volume issues. Apparently, there's a discrepancy between the clips that I play and my voice. Let me know when you're hearing things, if things are too high or too low. I'll try to fix them in the moment the best that I can because, I want to make this experience good for you. I'm also going to have to make a confession at the end of this video. I'm not going to do it now. It's just that I had the impression where I was under a totally different impression. Courtney already knows. So if I forget, Courtney, remember to tell me at the end. But I was completely wrong about something. But I want to hold off. And I'm not trying to build mystery, but I'm going to hold off because we are talking about day 22. I know that I'm a couple days behind, but this is Karen Reed's retrial. And it began with Judge Canoni addressing something that occurred the day prior. There was an objection at the end of the day when Dr. Welcher was giving his final opinion about whether he believed, with all the data and the experiments that he ran, that Karen Reed hit John O'Keefe with her SUV going in reverse at almost 24 miles per hour. And he believed that that was what caused his death. Not only did he say yes to that because that was his belief, but he added because that's what caused it. And usually, witnesses, especially experts, are prohibited from expressing opinions on what's called the ultimate issue in a case. Can you guys hear me just in case? Because I'm just going off and I didn't even ask. But let me know in the comments. I wanted to let you know what that meant because the ultimate issue is the key factual or legal question that's going to be answered. It's the one that must be decided by the jury to resolve the entire case. And the reason you're not allowed to give an opinion on that is because it really starts to encroach on the decision making role of the jury and the judge. It's kind of going too far. But apparently, in the state of Massachusetts, they do allow this. They go by the federal law. I think it's the Evidence 704 law, and it removed it from being like automatically prohibited, especially when it comes to expert witnesses. So if the expert's testimony is based on sufficient facts, reliable principles and methods, then they're allowed to apply that to the facts and give an opinion on the ultimate issue. So that's what was happening in case you were lost about like what's going on here? Why is this such a problem? Judge Canoni clarified this outside the presence of the jury and she did it in the morning. And I wanted to just play just a few clips because I think it's important to showcase that because it's actually not common. So we'll start there and we'll move forward. There's a lot tonight, and tonight's my night that I play games with my friends. So they almost canceled. And John was like, you're not gonna be able to go. And I was like, no, we're going. I told Courtney we're playing Sherlock Holmes right now. And of course we don't cheat. And I was telling her, when you don't cheat and you do everything and you're trying to solve a murder within the least amount of clues, it like helps me analyze these cases. I'm not kidding. You need to get the game. Not sponsored. But let's go on to the first scene. Here we go.
All
I don't know
right.
why it's putting the look how it's putting the closed captioning for a totally different video. Way to go. Let's turn them off for this.
Good morning, everybody. All right, so Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January.
How's the volume between me and the court? Just put it in the live, and I'm looking at all your comments already. Exactly. That's all I'm going to say.
29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application. However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling.
I hope you don't mind that I'm putting it on 1.25. I'm going to explain everything, so it's okay. You don't have to keep up with every little thing she's saying, but I think if we put this on regular speed tonight, we're never going to leave. And like I said, Sherlock Holmes, okay? So there you have it. He's allowed to give his opinion on the ultimate issue. So, of course, Brennan is going to come back and make sure, remember how I always tell you, they want to make sure the jury hears these important things, right? Because last time, maybe they weren't listening. It was the end of the day. They were falling asleep. So he was going to want to make sure the jury hears him say it that one more time. So we are going to listen. But first, he's going to talk about what he relied upon. And we already know, but the evidence, the photos of Karen Reed's vehicle, the doorbell footage, John's height, his shoe type, his lacerations and where they were, the text stream data. A lot of the comments from this day in particular were about him being like a screenager. And I'm talking about Dr. Welcher. I'm sure you know what that means. He was consistently, constantly looking at his laptop. He's not supposed to be looking at anything. He's supposed to be an expert. He's supposed to be doing this from memory because he knows what he's talking about. I have to say, I have not seen someone doing this as much. And somebody already commented that he was taking notes, he was writing on exhibits, and they had never seen that. I think Kelsey said that. Someone put that on the screen. I had never seen that either. Actually, you're supposed to ask the court's permission to look at your notes. And it did become somewhat of a problem, which was addressed by the judge multiple times. And he had to close his laptop. And I thought it was a little funny. We don't always get like humorous moments in court, but it's like a kid addicted to their device, you know? And I have to say, it shows that he might not be as confident in his opinion because on direct, he didn't have to do that as much, right? So I'm just giving a perspective of what the jurors may think. I'm not saying that that's what was happening, but he's giving his opinion on something very important. So let's listen to the beginning of court. And I think what we're first going to be talking about is that Brennan coming on.
I asked you yesterday about some of your opinions. I want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus and your arm.
Correct.
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight?
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows event, the nature and
Excuse me, Your Honor, pardon my interruption. I just want to know if he's reading from something or not reading.
Looks like he's counting on his fingers. Are you reading from something?
no, I am counting on my fingers. So I am counting on my fingers. The Ring video doorbell, Mr. O'Keefe's height, the type of shoes he's wearing because I need the same type of shoes. My exemplar inspection where I matched up the heights, the locations of the lacerations, and then the tech stream data as well.
That information that you considered, in addition to the text stream data you considered, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
Okay. I expected him to just say yes right out the gate. And I was a little surprised because listen carefully. I know you probably already heard all this, but just listen to what he says because this wasn't what he was saying before. He adds something.
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
Do you have an opinion whether, based on the data and based on the physical damage and your testing, whether that is consistent with a collision or a...
Sorry. So I don't know if you heard that, but he already said it himself that there are two potential theories. One, glass was thrown at the car, or an impact to the arm. And then he added, if it were at least 8 miles an hour, which we had never heard before. I don't even know where this came from. It was new to me. But what about John O'Keefe? So let's continue.
impact with Mr. John O'Keefe?
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you
So do you see how he says with that caveat?
have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
There you go.
In your testing, did you consider, or
I thought that was interesting. I'm just pointing this out because we hadn't heard it before. But his opinion was that the damage of the Lexus was consistent with the collision involving John O'Keefe at or around 12:32 a.m. on January 29th, which of course is the state's theory of the case. And this is all, in his opinion, with a reasonable degree of engineering certainty. And remember that because it's going to come up again, especially when the defense calls their first witness. And I know I'm going a little ahead of myself, but he will be a certified engineer, not engineered. But I just want you to remember these little things. And this is engineering research. And he's going to give his opinions, right? And that's his opinion that it was John O'Keefe's arm that was hit. And now we're going to go on to this next part. Oops. I always like forget where I am. So many tabs open.
in your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes,
What's your opinion?
that it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And does that specifically pertain to January 29, 2022, around 12:30 a.m.?
Objection, Your Honor.
I'm going to allow that.
Yes, it does.
Okay. So he believes that the injuries to John O'Keefe's arm, just repeating this, and head are consistent with being struck by a Lexus identical to Karen's Lexus and then falling onto a hard surface, such as frozen ground. Now, I've listened to so many videos in the last couple days. Courtney knows I'm kind of mixing things together, but I did think it was interesting that when he's asked about looking at the medical examiner's report, and I think this might have been from the day before, but I don't know if you'll remember this. He said that he looked at it. And yes, you remember she said that the injury could have been caused from falling backwards on hard ground. Well, I found it to be interesting that he's like, oh, I wouldn't rely on her report because she's not an expert in accidents like he's supposed to be, right? But in my opinion, and this is just my opinion as an everyday person that might be on a jury one day, who might be thinking like one of the jurors on this case, I found that to be a little snarky because I'm sure that doctor, I'm talking about the medical examiner, sees thousands and thousands of, does thousands and thousands of autopsies, sees a bunch of accidents, just like a pedestrian car crash that kills someone. So I just found that to be a little strange, but it's his opinion, and I understand that. But why wouldn't he rely on her opinion? The body is your biggest piece of evidence in any case. That's a reason why when I'm studying death investigation, like I am, they tell you the body is going to tell the story. That's why you get to the scene. And the first thing you're supposed to do, and we're taught to do, is take as many photos and examine that body as much as you can because you're only going to get one chance. Take as many notes as you can. That's your biggest piece of evidence about what happened to the victim. Their body tells a story. But in this case, what's so interesting is that the state's own witness, the medical examiner who did the actual autopsy that looked inside John O'Keefe's body, had concluded that this death was undetermined. And in her medical opinion, she did not see the normal signs of a vehicle pedestrian collision. That's all I'm trying to point out. I guess I hold her opinion to a higher degree, but maybe some people don't. And you may be on either side. I just remember a recent case where the state, I'm sorry, I don't remember a recent case where the state has gone against their own medical examiner that works for the state. But anyway, he's going to talk about side swipes. I can't even speak tonight, or glancing collisions. And this is where the momentum isn't fully transferred, like when you're directly hit. So I think that's important to talk about because I don't think that everything he says is bad or I'm on one side or the other. I'm just taking it in and I'm processing it. And sometimes I just call BS and I'm like, that doesn't make sense to me. And when it does, I'll let you know.
You've written some papers on sideswipe collisions or clipping. Can you describe for the jury and explain what a sideswipe collision is or a clipping and how that may or may not differ from...
Gordon and I have been bickering. We're like a couple now. We're like, well, what about this? What about that? Then you'll have to hear my little confession at the end. But sorry, let me repeat that.
More questions. You've written some papers on sideswipe collisions or clipping. Can you describe for the jury and explain what a sideswipe collision is or a clipping and how that may or may not differ from a direct hit on a pedestrian impact?
Sure. So what generally differentiates, say, sideswipes or clipping contacts compared to, say, an inline impact or, say, a T-bone impact is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you can have a glancing hit, and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's a glancing hit, doesn't completely transfer to the object being struck. For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car, and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer. So when you have glancing contacts, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
It's the same thing.
Oh my goodness, I'm so sorry. Don't look at that.
When you have a glancing hit to a pedestrian, this is referred
That's for later, and I was trying to set it up and didn't know I was going to show you. My bad.
to as a fender vault. In this case, they call it a fender. Fenders on the front of cars, because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash.
Sorry, I paused it too early. I wanted to really talk about this for a minute because he's defining this side swipe, this glancing or clipping collision, and it's one where momentum isn't fully transferred. That's unlike a direct hit. In side swipes, high speed impacts may result in minimal car damage because the contact is brief. And then he mentioned that pedestrians may experience what's called a quarter panel vault. I had never heard of that before. Rather than being thrown directly forward or backward, which I thought was interesting, and he's suggesting that that's what happened to John O'Keefe. But these type of impacts, he said, are difficult to reconstruct because there's a lack of a clear point of impact and motion. This made a lot of sense to me. I could picture this happening to someone. And guilty. I clipped someone's car a few years ago when I was driving a Lexus. I mentioned this to Courtney. My headlight didn't shatter or break, but my entire passenger side was badly scraped and dented. The other car, no damage, just a tiny scratch. And of course, horror because they were sitting in the car when it happened. So that was freaky. But he talked about the difference in the injuries to a pedestrian hit this way opposed to being hit straight on, which is going to be even more important, which is why I was going to put that on the screen for you, but just hang on.
If the impact had occurred in the center of the vehicle and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle was going. But when you have just a corner clipping or glancing, it makes it more difficult to determine, even when you have an area of impact, which is where the person was when they got hit, and a point of rest where they landed, makes it more difficult for glancing contacts because you have that Sideswipe problem where they don't obtain what's called common velocity.
So I hope that's making sense. I mean, you really just have to think of it as kind of easy to explain. Like when you're hitting someone straight on or someone's getting hit straight on, they're going to take most of that impact. But if they're getting hit by the side, it's only going to be a moment, but the velocity can still propel them. We're going to hear how and why and not where, but he's going to explain a little more. But I just thought that was interesting because that is what they're trying to prove.
And what are some of the other difficulties in attaining specificity in a sideswipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen. Post-impact motion of the person. So cadavers, crash dummies don't have any muscle reaction. So the motion of a crash dummy is just going to be like you're hitting a dead body, to where people will step, try and regain their balance if possible.
This is really interesting. He just said, we'll do additional activities that alter where they come to rest. Welcher was trying to explain that injuries in a sideswipe, they vary based on the position of somebody's body, whether, let's say, a foot was on the ground or not on the ground, or which foot it was, whether you jumped up or you reacted in some way, or you like put your hand up or you lowered it. I thought this was so interesting and actually really on point. He said human bodies react in ways that the crash dummies will not. You know, they're not going to react. They're not going to break their fall. They're not going to be like a real human being, right? So, pedestrians, that's different. It's going to also lead to different injuries. You know, this was really good because I feel like it was really credible when he was explaining, because I can imagine a person and they would move after being struck. Like, even if it is fatal, like the Dr. Wolf, remember he talked about like the body and it doing like a weird like caveman type movement when it knows it's being attacked in nature. I mean, that was kind of weird, but I understand what the whole like reaction would be. If you're still alive, you're having even a seizure or you're stepping back, that's going to happen to the human body. But a dummy is not going to be going through that. When it falls, it's just going to be where it landed, right? But he went on to explain lower body injuries and that they're not always guaranteed to happen, even if the speed is higher. This is also really important for their case, which is why I'm presenting it.
When you see direct impacts, is there
Sorry, I'm moving the closed
ever
caption.
the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Actual Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
No, it is not uncommon.
Have you had cases that you've studied or been involved?
Okay. Before we go any further, there's going to be a deceased individual on the screen, so I'm obviously not going to be showing that. Let me see if I can find what I did want to show you. Um, First, he's going to be talking about something unrelated, so I can still play it here while I'm looking for the photos. But yeah, I'm definitely not going to show those on screen because they were very gruesome, and I don't think we need to see it in order to understand it. So let me keep playing, and I will hopefully pause it in time.
Involved with, where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities.
Yes.
I'd ask you to turn to slide 139, please.
Okay, I'm scared to go there. I'm going to show you screenshots from this. Okay. So, what he's going to talk about, there are lower body injuries that happen, like broken legs, and that can occur, but they're not guaranteed to happen, even at 15 miles per hour. And then he decides to share a real life case study. I should say a real death case study, like I can't show on screen. Now, this was a pedestrian, and they were hit, I think he said, going 25 miles per hour in LA, in downtown LA, right here in LA. I'm like, yeah. And he works here in LA. So this man had a severe head injury, but no broken legs. And what he was trying to show with this person lying on the ground and then the car that I'm going to show you in the damage is that he had this really big laceration on his arm and he had rib fractures, but he didn't have broken lower extremities. And this is what he was trying to get like across to them is that you're not always going to see breaks when you're sideswiped, especially in this case study, because in my opinion, I'm like, the condition of this vehicle that I'm about to show you, in my opinion, and you can look at it for yourself. I'm going to put it on the screen in 1 second. Here's the car. So let me show you the car. Oh, wait, is it going on the screen? Yeah, there it is. Okay. So this is his case study. This is the car that hit the pedestrian. And in the lower picture, you're seeing that headlight area. And in the top, you can see the hood is dented, the side fender is dented. There's a lot going on there. We're going to come back to that because now I want to show you um, the area of impact, which he's going to be talking about. I hope I did this right. I circled the area of impact, and you can see this is on the road, and it's circled, and there's a little dot. And then there's another photo. It's the first time I'm ever putting the pictures in while I'm doing this, so bear with me. And the other photo is the bottom half of this photo, and it's showing the area of rest. So you can see how far the body went in this side swipe. However, I just want to note this person, this man, was severely injured, severely. And you can tell that it took a massive amount of force. I mean, I understand that maybe he didn't have lower extremity broken bones, but his other injuries were really severe. Okay. I mean, if you saw it, you would know what I'm talking about. But that's quite a distance in that description that he gave. That's quite a distance. And the damage, I forgot to tell you this. That damage that you saw, let me bring it back up. Okay. The bottom picture, that's actually, if you look carefully, that's actually tissue, human tissue, blood, and hair from the man's body. So if you think about it, and I'm going to go over his injuries in just a second. Let me put him up on the screen while I'm talking about him because that's going to be important. I want to make sure that you know all about every injury. And it's so blurry, okay? Only reason I wanted this up is not even so that you can read it because I'm going to read it to you, okay? But I thought it was important to know all the injuries that were listed. He had abrasions of the lower back and buttocks, right subdural hematomas. Okay, I'm not going to pronounce this right. It's subarachnoid. Am I saying that right? Hemorrhages, ventricular hemorrhage, fractures of the right posterior ribs. A lot. Look at all this. Multiple abrasions. The liver laceration, bilateral hemothorax. I don't even know what that is. He also had the right upper extremely wounded. Oh, that was the injury to his arm. Okay. The injury to his arm almost looked like there was a chunk taken out of it. And then you can see there were multiple abrasions. We're talking about the right knee, another one on the right knee, The left anterior leg was red. The lower back was red. The lower right back was red. The left buttocks was red. They're just talking about a mark. But remember that there were some red marks on John O'Keefe. So that's what he's trying to do. He's trying to compare it. And also, this person's right leg was red and his right ankle. So, and he was on his back. This victim in this other case was on his back. If any of you saw it, let me know. I would argue this was way different. I mean, how do I know, right? But it looked way more severe. There were way more injuries to this victim's body than John O'Keefe. And I guess the point in here with him showcasing this, and it was gruesome. And I understand that he didn't put up there to be like shocking anyone, but he was saying even up to 25 miles per hour with such a severe accident, that man didn't have a broken arm and he died, but he didn't have a broken arm or leg. But again, I would argue, but you can clearly see that the car like, like impaled him. The front of the car took a portion of this man's arm, even if it wasn't broken. It's like it missed the bone. So it already impacted him and then he already flew and there wasn't time. Like even in his argument, if you're sideswiping somebody, it's quicker. But remember, that is the Commonwealth's point in all this, that this is a sideswipe. So it's going to be different. And John's is a sideswipe. And in their opinion, that's why he didn't have the same impact to his bones and his legs that you would in a front collision. But I thought this was a pretty good argument, I think, for both sides in many ways. And then Brennan asked if the injuries to John's body were consistent with a sideswipe collision. So I think it's important for us to go there. And I know there's a lot of comments, and I got a super chat this time too. Oh my gosh. And I'm going to make sure that the super chats are displayed way better on Monday because I'm getting a new system. But thank you so much. I didn't know if it was Anna or Anna. Remember I asked that last time? And it's the parrot character dancing under a rain of confetti and taking his hat off to say you're amazing. Thank you so much. I really do appreciate that so, so much. And I will get to the rest of the comments. I'm favoriting them. So if you're not here on the live, you can always come back to the replay and see if your comment got answered. But yeah, let's go to the next portion of the trial.
Dr. Welcher, regarding your analysis of the data and the evidence in this case, do you have an opinion to a reasonable degree of engineering certainty whether the absence of lower body brakes to Mr. O'Keefe is consistent with the defendant's Lexus impacting in a sideswipe or a clipping Mr. O'Keefe?
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
That was it. That's the only part I wanted to show you. And now it's what you all have come here for. I'm kidding, but it is the cross-examination. And something right away, I don't know if anyone noticed this, but did you see how pleasant Dr. Welcher was when he was being questioned by Brennan? He seemed sure of himself. He was confident. He seemed calm. Well, that's going to change when he starts to be questioned by Alessi. And if I were ever to instruct an expert witness in the future how to not testify, I would tell them, don't be a jerk, because it's not going to make you look good. Keep the same cool, calm, collected demeanor that you did when you were on direct, just like Dr. Wolf did. Remember Dr. Wolf? He was the Commonwealth's witness that came in. He was the neurosurgeon. The man kept his composure. That's not going to be true for Dr. Welcher. And it's not a good look. Some people just don't do well under pressure. I understand that. But of course, you watch and give me your opinions. I already saw some in the live comments. And there was a lot of people saying while I was on live that he came off as narcissistic. And I mean, when I was watching the trial, and that he was a know-it-all, and that he couldn't just answer a simple question. And I do admit, though, Alessi came out swinging. But this is when Courtney and I were going back and forth and debating this. And I was like, listen, that's his job. The defense doesn't have to prove anything. They have to refute all the evidence. So he has to try to impeach this guy, make him look bad. That's what he's supposed to do. Alessi is not the a-hole. But the first topic that he wants to touch on is forensics. I feel like we do forensics, and there's like a music to it. But, and I also like everyone to learn in these videos. I'm sure you know what forensic means, but it's the application of all kinds of scientific knowledge to legal problems. And it usually refers to things like testing, techniques, but they're used in the connection with a crime. So anytime you hear forensic before something, for example, forensic psychology, that would be psychology, but it would be related to a crime. So most likely that person would be doing an analysis on someone that's standing trial, maybe to figure out their mental health and what it was like related to what they are being accused of. And then something like forensic pathology. Pathology alone is a medical science, right? That studies causes, nature, the effects of diseases on the body. But then when you add forensic to pathology, I'm sure you can guess, it's a special type of pathology that's now focusing on the cause and manner of death in investigations, which is what we always hear. Those are the kind of pathologists that we hear when we're listening to trials because it's connected to the law. That's what it means. That was long winded. I hope you learned something about it if you didn't already know, but let's hear that now. And I think I might have gone a little forward, so I'm going to go back a little bit. I can just tell we're not where I wanted it. Okay.
Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella
Okay.
of you basically
Hold on. Sorry, I've got a request here. Let's go back.
Morning, Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Alessi. Nice to meet you.
Nice to meet you.
Do you want to go grab a drink later? I'm just kidding. It was just funny.
Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in, giving scientific evidence in court applies to forensics. So my main job is action reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. When it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part.
We should make t-shirts that say law baddies because we're not daddies. We should just be like the law baddies, and then we'll all know what it means. It's so funny.
With regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking?
That's exactly it.
Okay, yeah, certainly for the court of law,
It
yes.
ends up to a court of law, and forensics is a common term.
Yes, sir.
So it relates to, or it's used in, or it's suitable for a court of law, the analysis. You'd agree with that's a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in here in a criminal matter, correct?
Yeah, you're trying to apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible.
I didn't stop it because I was reading the comments. What Alessi is getting at right here, and this is why he's asking about forensics, because he's saying, this is going to be used in a court of law. You know that it's going to be related to a crime. But what he's getting at is objective, non-biased truths. And Welcher makes the statement that truth is subjective. That was what was in my thumbnail. That's what I thought was like the most important part of this. I probably didn't even let you hear it yet. I think I need to go back a couple seconds. But it's going to be interesting to hear about this, and we can talk about it because I think it's interesting. So let me just go back a couple seconds.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Certainly objective information. Truth sometimes, again, can be subjective.
Truth can sometimes be subjective. And some will argue that it shouldn't be. that there should be objectives, like objective truths, universal laws, if you will. And science is usually one of the places where you find those kind of truths, like math and science. 1 + 1 = 2. If I combine this element with this, it's going to cause that. There's no personal emotions or preferences in something like math. And we know that Dr. Welcher's entire presentation is based on numbers. So I kind of thought the answer was interesting. And I think that's what Alessi's getting at. He wants to prove that, is he using the scientific method and using it correctly? And if he is, shouldn't everything be objective? And then while I was listening to the trial, my husband, he heard that part, Jonathan, okay? And he's like, I think his answer is subjective. And I was like, touche, because it is interesting, right? We're all going to look at things differently. I mean, the jury is going to be looking at things differently. But I think this is interesting that he was talking about evidence being people's testimony and taking that into consideration and not knowing whether it's completely true or not, that it could go either way. So he's like, well, I want to be objective, but then I've got, someone's testimony. So it's not always going to be objective, but we're going to try to be. But now Alessi's going to question whether he's neutral because he made a claim on direct that he had no dog in the fight. Do you remember that? Well, we're going to touch on it. And I think we're going at a pretty good pace and we'll get through all of our clips. I feel like a teacher, like, we're going to get through all of our clips tonight. But here we go. Let's listen to another one.
Part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method, is to avoid biases?
The purpose of the scientific method is to get the most logical and correct answer without bias.
Exactly. To do it apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So are you familiar with the term confirmation bias?
I am.
And that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, biases are, don't you agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies?
We don't have to go too much further because what he's trying to get at is that, well, Dr. Welcher says that he's following the data and that it's not perfect. And he's trying to do it as best as he can in this case. But it sounds like to me, on one hand, this could be the whole like cover his butt type of situation where he's like, well, I tried to follow the data as best as I could, but I'm only human. And this is when I started to see his confidence kind of dwindle. I mean, yes, you're only human, but you are the expert that's going to either put someone behind bars for the rest of their life or tell how somebody died. So I think you have to be pretty confident. And now they're going to actually review the scientific method, which they kind of already did. And he wants to emphasize the importance of testing hypotheses and to avoid confirmation bias. And that was key. And Welcher agrees that, and I don't want to get too ahead of myself, but he's going to talk about multiple hypotheses and how they can exist. And I thought that was really interesting. But then he was losing me at one point. I was like, you're off the rails. And you'll see what I mean. He was off the rails. He like wouldn't answer. I'm going to look at your comments while we're playing this next part. So if I go a little too far, I'll go back.
Are you familiar with the term failure analysis?
Generally,
I think I went too far. Hang on. Let me go back really quick because I don't want to miss this. I think I went back. Let me go back. Like, what's the point if we don't hear the right one, right?
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty. Is that correct?
correct.
Have you used the word sometimes to reasonable degree of scientific certainty?
I might have.
Right. So
I don't know.
in terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
Critical analysis? Yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
Remember that? He just brought it up.
I did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That is
correct?
100% correct.
Now, you simply follow the data. Is that correct?
I try to do that.
You try to do that.
I'm not perfect. So
Okay.
I do my best. I believe I've done it here.
Okay.
So he does his best and he thinks that he's done it here. When I heard that, I was just like, okay, that doesn't give me that. If I was a juror, I'd be like, ooh, I hope he did his best.
In terms of you've agreed that you apply the scientific method, so I want to see if you're in agreement generally so the jury can understand what the scientific
Wait for the roller coaster that's about to happen. Hold on to your seats.
method is. Are you familiar with NIST, National Institute?
Yes.
Yes.
This was my favorite part.
So would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem, the collection of data through observation and experimentation, analysis of the data, the formulation, evaluation, and testing of hypotheses.
His brain just went back to elementary school. His brain just went back to, Mom, I have a science project due tomorrow. Remember the 3-panel? That's where his brain went. He's like, scientific method, scientific method. It was funny because he's looking down and I just had to laugh because I was like, we learned this in middle school. No, it was like elementary.
And where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial or things are in evidence. So frequently there's one or two versions, and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses, and where possible, the selection of a final hypothesis is the scientific method, correct?
Generally, yes.
Generally, yes. The scientific method hasn't changed since it was created. So I just had to laugh at this because it's just, he doesn't want to answer questions. It's like pulling teeth. So they go over the scientific method. It's all about avoiding confirmation bias, right? And finally, he's agreeing you can have multiple hypotheses that can exist, and the one that best matches the evidence should prevail. Even, even though maybe we didn't think so, or it's complex and we don't want to go down that road, but he did explain that, everything has to be taken into account. And it's like, he's just asking you, he's just trying to get him to say like, yes, confirmation bias, right. We're going to do the scientific method. It gets worse because then he's going to get into not understanding the question. Either he's not understanding the question or he's purposely just trying to avoid answering. And I can't figure it out.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So I've done my analysis here, biomechanical analysis. I can't submit this analysis for peer review. I'm not allowed to give this to people outside the court.
He is all the way across the his brain has left the chat. His brain, he needs his laptop. He needs his comfort laptop right now. He's going off the rails. He's like, wait, I can't have this entire, experiment, everything I did be peer reviewed. But that's not what's happening. He feels like Alessi's trying to check his work. That's not what's happening here. He either misunderstood the question or he's talking about, are your methodologies, how you're testing this, have those been peer reviewed? That's Alessi's questions. And again, it seemed as though Welcher is he's not getting it. He's really lost. He's talking about, I can't peer review this, the judge, this. He's like looking at Bev. excuse me, Judge Cannoni. But let's hear this.
So there would be no way for me to submit my analysis for peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process. The methodologies underneath it, and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science. 26.
So I think you may have misunderstood my question, sir. I was talking about your methodology, your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis.
I'm
so
sorry, sir,
to
to
get
interrupt
peer
you.
Oh my gosh, he doesn't get it. I'm sorry. I feel bad for him at this point because I'm like, sir, what is going on? You feel like you're being attacked, but you're not. You're just, and rightfully so, because he is being attacked, right? But all that Alessi's saying is like, are your methods that have been tested? Like, are they valid? He's testifying about whether someone's going to lose their freedom or not, whether somebody died a certain way or not. That's a really big responsibility. But let's continue. Sorry I had to put you through this madness, but
I need to.
Go ahead and answer your question.
You're asked peer review, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir, my question is not your analysis here in this case.
Oh.
My question regards the methodology that you used here. Is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this manner? Is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think with the forensic application, yes.
Okay, that's
it was like pulling teeth. I was like, just, it's a yes or no question. But do you see how it's getting harder and harder? But to be fair, maybe he didn't know what was going on in that moment. Like you're tired. You've been up there for a long time. I get it. I'm not trying to say 100% that he was being evasive or anything, but I did get some super chats. And one, Odamaris said, super chatting to pressure you into the law baddies shirt. I'm going to do it. Jonathan's going to do it. I'm going to make him do it tonight and I'll have it ready for you and I'm going to wear one. I mean, it has to come in the mail, but I'll get them up as soon as I can. And then I got another one from Kat. Oh, thank you. I love watching you, Kimber. Keep doing what you're doing. You're amazing. Love from Scotland. Ooh, I've never been there, but it's beautiful. It's beautiful this time of year, I've heard. But to get serious, it was like pulling teeth. He can't answer the simple questions. And it's going to get even more interesting. Let's see if we have the next clip. Did I go too far? Oh, I always do this. I feel like I went too far. Let's just see.
hypotheses. Would you agree that those hypotheses should be tested?
So if you take the word testing to mean testing compared to testimony, compared to physical evidence, yes.
And
I was like, wait a minute. If you're talking about testing, should hypothesis be tested? And he was like, well, sure. Yeah. I'm like, I don't know if I'm even getting lost. I'm like, wait a minute. So let me go back a second. I know I keep going back, but I feel like we missed something. I think I want to go to like right here.
hypotheses, once an initial hypothesis
Here.
that contradicts those beliefs, is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader.
This is important. Hold on.
An expert on cognitive. I can talk to you
I think he was also really confused on definitions. Like he kept asking about like cognitive biases and stuff. And he was like, I can talk about confirmation bias if you like.
about confirmational bias, if you
Sure.
like.
Let's talk about confirmation bias. Now, confirmation bias is actually when someone selectively gathers and interprets evidence to confirm one or another's beliefs as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what
Generally, yes.
confirmation bias is. And an example of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be yes.
It's like, no, it is. If you have one or more theories, right? Let's say you start with one theory or hypothesis. And as you're doing your testing, which is definitely something you have to do, it's starting to look like the hypothesis that you thought was right, it's not. And there's another one that leans more towards the truth. Then confirmation bias would be circumventing that. And the examiner that's doing the test would just hold on to their hypothesis from the beginning to make sure that it was true by essentially skewing the data, which is what Alessi in the defense is pretty much accusing Welcher of doing. So that's why they're talking about this. And now they're going to talk about failure analysis. And I had to look this up. I know Welcher doesn't have the opportunity. I mean, he does have his laptop there, but I looked it up because I didn't know what failure analysis actually was. I could think about what I thought it was, but I looked it up. I was hoping to get a better idea before we jumped into this. And this is just a way to investigate the cause of why something happened, why it failed. It's usually a product, equipment. It could be a mistake that happened in designing something or during the manufacturing process and why it failed. And I found this to be a very interesting topic because that's kind of the point that Alessi's trying to make is that you'll see.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury is, how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you...
So hold on a second.
Okay,
Generally, what you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen?
I was like, what? No. You have a question in the beginning and then you try to answer it. So he was doing this backwards, which I thought was concerning. I was like, no, before you begin your research, you're going to say something like I was earlier, like you see a body lying on the snow, they're dead. And as a death investigation would be going on at that point, you would get to the scene, you would look around and you would want to know, how did this happen? And we're going to start with the body because the body is going to tell a story. But Welcher and his process is the other way around. He says, no, I start looking at all the evidence and then I determine what happened. And my brain was going to explode. I was like, sir, you wouldn't have even been hired in this case if the biggest question wasn't what happened. How did this happen? So you wouldn't even be asking about the black box or injuries if you didn't even know what the scenario was, which is that someone died, that John O'Keefe died. And at this point, I was thinking that he was just trying to be difficult. You'll hear it.
So that's the end.
I think you may have misunderstood my question, sir. I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is, where's the damage? What are the injuries? What's the evidence?
Okay, someone's dead right there. You come to a death investigation. What's the damage? It's like, I'm sure someone's going to ask that question, but I think the first thing anybody would want to know, especially professionals, like, what happened? What happened? There's a group I'm in on Facebook called Death After Dark, and it's a true crime society like spin-off. It's all about what happened. Everybody's posting. You know how when you see somebody say on their Facebook, I love this group, by the way. When somebody posts on their Facebook, I am grieving the loss of so and so. My alarm's going off. I'm grieving the loss of so and so. And they put this whole long spiel about what happened. And you think to yourself, how did they die? And you're like feverishly like Googling their name. This group will help you with that because that's what it's all about, finding the information about how they died. Anyway, let me get my alarm while I'm playing this.
What black box or text stream data do we have? What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Correct. But when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
But you would agree that for you at least some point, it's how did this happen, correct?
Yes.
And don't you ask that question to come up with hypotheses?
I generally have many working hypotheses as I'm working on the case. And then as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the
Now I'm blurry. Hang on.
factual information.
Sir, how then is it just a matter of logic or a syllogism? If you don't ask the question, how did this happen until the end, how do you then not get your hypotheses up front when, under the scientific method, you should be having different hypotheses up front? How is it that you ask the how did it happen at the end
I'm having a night.
and not go through hypotheses in the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like I was trying to give you an
It's either he's always misunderstanding because I almost feel like he wants to be like, no, this is my process and my process is not like your process. And we're never going to see eye to eye unless he's just, I don't know, trying to get out of making himself look bad or something. I just don't know why he's avoiding the question. But honestly, the back and forth, it was driving me crazy. It's just like two people that are never going to understand each other. And maybe that's like some people in the chat, but at least we're nice to each other. And by the way, I got a super chat. Dr. Angelique, hope I'm saying her name right. Kimber for judge. I mean, maybe one day. I don't know. That's a long time to become a judge, but I really appreciate your super chat. Okay, here we go. Wait, you're not watching on the replay. You're here with us right now, Gary. All right, here we go.
an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
So
That's what he was just saying. All that was to get to his next question. All he was trying to do, all Alessi was trying to do is set up his next question. That's like it is. It's like tennis. You know, you're like setting it up and you're hitting it and you're going to do your next shot. These aren't supposed to be these elaborate questions. I mean, this could have taken half the day. I mean, it's all about testing a hypothesis, right? And any elementary school child who has literally done in a science experiment knows that you start with your hypothesis. You're like, why does gum lose its flavor? Why do frogs have bumps on their back? That's our curiosity. That's the existence of like human beings in this world. And as we learn as children, that's how we identify the reason why something happens. So my brain was finding it very hard to understand why it's taking this doctor so long to just admit that the scientific method is the way that it is. And you start with the hypotheses. I just didn't understand this. I was like, what is going on here? But let's continue because there's more. There's more. I want to fast forward just a tiny bit. Okay. Like just a tiny more bit. More bit. Just a tiny more bit.
hypotheses, would you agree that those hypotheses should be tested?
So if you take the word testing to mean
Now he's just effing with everyone. He's like, hypothesis should be tested. Like, think about that. I'm sorry to laugh. This is actually not funny, but it is. We can laugh at these things because there's got to be humor in or else we're going to cry ourselves to sleep at night, right?
testing compared to testimony, compared to physical evidence, yes.
And when you test those hypotheses, isn't it often the case that, particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it.
That's why you're doing the experiment.
Again, sometimes we get very unique injuries.
So my question, sir, is this. Isn't it the case that when you have multiple hypotheses, the
I wish I multiple hypotheses. It's like you have done the scientific method since elementary school. We all do multiple hypotheses every day. Why is it smelling here? Oh, it's the garbage. Or it could be a dead rat. Or you are literally trying to figure out which one of those hypotheses, those guesses, are true. I just don't understand why he doesn't understand why the scientific method works. That's how it works. These questions are not supposed to be complicated. So I don't know why he's talking in circles and wants to just clarify every answer.
one that most, out of all of them, it's a relative thing, the one that most
Laura.
consistently produces the same injury emerges as the mechanism of injury. Is that a fair statement?
I think generally, again, it's on a case-by-case basis. You have to look at the science and the facts of what you're basing it upon.
So what he's essentially saying, and Alessi was struggling, he's essentially saying like, oh no, even if one theory looks better, it depends. I'm like, oh my God, I was like literally scratching my head. I'm like, that's not a good answer. That's a bad answer.
I think as a general premise, what you're saying is accurate,
Okay,
but there's exceptions.
fair enough. But it's a general principle
Sure.
with some exceptions. That's a fair statement, correct?
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clear is I'm going
He's like babying him right now. And this is funny.
to say when I'm switching topics.
Oh, good.
So what I'd like to do now is switch topics.
Okay.
You're
He's like, sorry that I have to like literally spell things out for you, Dr. Welcher, but you're having trouble with the scientific method from elementary school. So I'm treating you like a fifth grader and I'm telling you that it's potty time. I was dying. I was like, this is my favorite part. Okay, but to get serious, there should be a winner. When you're trying to figure out what happens in a case like this and how these injuries occurred, you're going to have one theory of the injury that's going to make the most sense, and that's the one you need to go with. Okay. So this was also the beginning of him checking out, in my opinion. You can have your own opinions, but I think he was just steadily relying more and more on his notes and on his laptop or whatever he was doing. I'd never actually seen a witness do that before, so just watch as we go. But at this point, Alessi asked him if he knew that the state police had troopers that were dedicated within the department to investigate accidents. They had accident reconstructionists. And whether he knew that, he said no, he didn't know that. But in this case, he did see people that were doing that. Like he knew people were doing it. So, and the reason why he was asking this is because of Trooper Paul. If you hadn't seen the first trial, you wouldn't know about Trooper Paul, which could be a good thing or a bad thing depending upon how you're looking at it. But there were a lot of funny memes that came out about Trooper Paul and the whole how do you even say it? I can't even say pirouette. Yeah, I couldn't even pronounce it. I have a hard time with that word. But that was Trooper Paul's testimony. He was the first accident reconstructionist that was hired by the state to come and testify. Well, he was working, works for the state police. So he wasn't hired necessarily to testify, but he came in the last trial and he just bombed. So what the defense is trying to point out is that Trooper Paul, he isn't back this time. And there is a reason for that. He's hired instead. Okay? And Courtney says, to be honest, if I were a juror, I would have tuned all this back and forth out. And that's sad. Because what if this is like serious? I mean, it is serious, but I'm like, what if this evidence would have been like the most pivotal, and the state thinks it is the most pivotal part of this entire case, and your witness is just off the rails. So that is sad. And I do feel bad for that. But anyway, just watch him start to kind of, get worse and worse with looking at his notes and doing things at his desk. Okay?
You're aware that the Massachusetts State Police has troopers who specialize in accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction Section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction Section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right, based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts state trooper named Joseph Paul, P-A-U-L?
Yes.
And you
Well,
know...
I'm familiar with his reports. I don't know the man.
Okay, familiar with Trooper Paul through his reports in this case, correct?
Correct.
And are you aware that he was assigned by lead investigator, former Trooper Michael Proctor, to be a constructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you know that?
Well, you put a lot of things in there.
Trooper Proctor. That's all we want to know. Did you hear Trooper Proctor? Did you know that he hired Trooper Paul? He's like, well, you put a lot of things in there. Indeed.
I know he issued a reconstruction report. I don't know who told him to do it. So the first party question, I don't know, but I did see a reconstruction report from him.
Probably another reason why Trooper Paul is not back.
You were retained, and so do you recall, is it the date, January 29th of 2022, is that a rough time period of him being assigned, or you don't know when he was assigned?
I don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
He's like, I don't know when he got his assignment.
Do you know when, the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
So what he's getting at is 2.5 years after the incident happened, Aperture was retained. And then on November 5th of 2024, they were paid $45,000 to do the work, and essentially the same work that Trooper Paul had already done. That was important, right? And then he's going to be questioned about the fact that he's the senior vice president of Aperture. Yet he's kind of acting like he knows nothing about the payments that were made. And maybe that's true. Maybe he's so far up the chain, he doesn't handle any accounting, fair enough. But this shouldn't be a big deal. You should just answer straight up like, yes, I signed a contract. I know how much money they were paid, because witnesses get paid. It's a known thing. They're doing work. It's their job. So this should have been easy, but it wasn't. It was like pulling teeth again.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple days. Okay.
Correct.
So
Actually, I might be able to find out if you'd like me to look at the documents.
it's not.
He wants to look at his iPad so bad. So bad. He's like, I need it. I need it. It was like a screenager.
Not all that important. You would say it's within a week of September 23rd, 2000. It
Wait, he's looking at his laptop again.
was in September of 2024.
I believe it was in September, yes.
Right,
I would
so-
want to double check.
That's 2.5 years from the date of the incident in question, if I did the math right, correct?
No, I never thought about it.
I never thought about it. Like, even on this case.
Yeah, approximately.
And as we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct.
On November 5th of 2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea.
This is a really good point made by anyone seen Bev's Grave Concern. Good name. Does anyone else feel like they understood Trooper Paul more than Dr. Welcher? Actually, yeah. And then when I was hearing them say spinning, like now the Commonwealth has talked about spinning the other day, I was like, wait a minute. I was like, I think we need to get Trooper Paul back in here. Like, are they saying the same thing but being paid more? Anyway, let's keep going. He doesn't get the billing statements.
I don't get the billing or the statements.
Hi, Kat.
Do you recall whether Aperture has, well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So
we're
you
an
would-
engineering company. We bill for our time.
So you know that Aperture is getting paid for its work in this case, correct?
We are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir, you are a senior vice president of Aperture.
He's the senior vice president of Aperture, but he knows nothing. But like I said, maybe, it's true. Maybe he personally doesn't know anything about that. He came on board later too. He came September of 2024, not in the beginning, but Aperture was being paid and it turned out a lot more.
Are you not?
I am.
You would know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024, wouldn't you?
Dark Livity's here.
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
He's got to wait a year to get paid.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months.
And this was the worst part because he's like, you were here for 2.5 years. He's like, no, I was only here for 5 months. And then that became an even bigger thing because he's like, oh, wait, you've only been here 5 months and you've been making all that money? Because we're going to add it up and you probably already know it was like, it's actually closer to 400,000.
If you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's, less than a year ago.
So you're even getting paid more in a sense. I told them, Jonathan, that I'm going to be playing games tonight. So they know that we only have a little bit to go.
Understood. I'm moving on to the next question because I want to move away from that discussion and just go right to the bill.
He's like, I just want to go right to the bill.
You, as you sit here today, do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection. I'm not part of that process. We have an accounting department. I don't have any involvement in that.
So is your testimony you have no knowledge about any contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth to sign, so I'm aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay. So you're aware there's a contract between Aperture and the Commonwealth.
I signed it.
And you signed it. And was it that contract obligating the Commonwealth to pay for the services of Aperture? Isn't that the purpose of the contract, in part?
In part, sure.
Yeah. It's a legal obligation of the Commonwealth. Your firm does work, and the Commonwealth pays for it, correct?
That's the idea.
Right. And so you know about that contract because you signed it.
Correct.
It's not a bad thing. Just say, like, yeah, I signed it.
Also, you testified on direct that there was a purchase of a Lexus exemplar for your testing.
Correct.
Who pays for that Lexus exemplar?
Aperture?
And is that then cost passed on to the Commonwealth?
No.
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is we paid for the Lexus, we're keeping it till the trial's over, we're selling it, and charging the Commonwealth the difference in the price.
Exactly. That was where I was going, sir.
Exactly.
But they're only paying the difference. So, and in theory, if we sell it for more in California, then we'll reduce the bill.
Okay, I don't want to speculate. I just wanted to see what the obligation was. So
The obligation is the difference.
Exactly. So the obligation is the difference. Are you aware that on April 5th,
Here it comes.
2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
Okay, so to fast forward through this, I mean, we already heard most of this, but what he's implying is a potential bias because that's a substantial amount of money to get paid. And of course, he wants more work in the future. And I mean, whether or not, I mean, every witness is going to be paid, right? Defense witnesses are paid. But remember, the defense doesn't have to prove anything. They don't even have to call one witness. It's the Commonwealth or the state that has that burden, and they are willing to pay a lot to secure it. And that's the point. And then he goes on to say, like, we have 3 offices working on the case. It was a lot. And the whole thing that Alessi's just trying to show is like, yeah, you're getting paid a lot. So doesn't that mean you care about the outcome? And not to mention the fact that they had to go to like a different state to find somebody. I mean, they said they had an office in Boston, so fair enough. But they had to go outside of just their state troopers that already do accident reconstruction to pay someone to get a different narrative. That was kind of the argument. But then we are going on to the updated PowerPoint presentation. That was a really hot topic, and we only have a few more to go through. So I don't want you to feel like this is going to be too daunting, but I think it's fun. And this was all about, oh, actually, we have to play this because this is when the judge gets on him about his computer, I think. So let's go and listen to it.
Okay.
You submitted an updated PowerPoint presentation, the one that you went over on your direct examination. You created that presentation quite recently, correct, sir?
The updated one.
So Courtney had a good question, and I want to talk about it for a second. She said, but is that a gotcha moment? All the experts get paid. It's not the fact that they got paid. That's a really big amount of money. Maybe a witness makes 20 grand, like their entire time they're on a case. Maybe they make 15 or 5, depending on how long they testify, how many days they have to be there, the travel. That's a lot. Like $400,000 is pretty significant. I'm not saying it's unheard of. I'm not saying that another evidence expert doesn't get paid that much, but normally, take Dr. Wolf, for instance. He said 1% of his income comes from being a witness. He was an expert witness as well, right? He was an expert in brain injuries and neuropathology, or not neuropathology. Sorry, I take that back. Or was it neuropathology? But he's only there for a day. He comes and goes. He's not working and working and working and working towards it. Some experts just analyze something like a report and they're paid for their time. But all this is showing is that they've been on this case for 2.5 years being paid, buying vehicles, going above and beyond. So it's not wrong and it's not a gotcha moment, but it's just cumulative. What Alessi is showing is like, look at this, look at this, look at this. He has to keep, like whack-a-mole, like look at all these things that the state had to do in order to get their narrative to work. That's the argument. And that's just more evidence to prove it. Because remember, his job isn't to prove anything. It's just to refute everything and say, oh no, the only reason you're doing this is because you're getting paid.
Was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this. The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks? 2 weeks?
I don't actually know without looking at the documents.
Well, was it more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after April 22nd of 2024?
I don't know.
Uh-oh.
Do you know when...
Hold on one second. Dr. Welcher, I'd ask that you not do
Not look at.
anything.
Okay, I was going to try and answer his question. My apologies. I will shut it down.
Thank you.
You're welcome.
If I may, Your Honor,
Yes.
continue.
The judge was telling him, you can't look at your computer, sir. And he's like, okay, I'm going to shut it down. I'm going to shut it down. This isn't going to be the first time. This isn't going to be the first time.
Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting
Your
to do.
Honor, may he do that?
Yes, I'm going to see counsel at sidebar while you pull that up,
Thank
please.
you.
The judge was getting a little snarky right here. She was like, no, I don't like this. This is my courtroom. I told you to put it away. You didn't put it away. They're going to have a sidebar. Okay. And when they come back, the judge is now going to direct the doctor, Dr. Welcher. And she says, after you're done answering that question, you need to shut your computer down. So I thought that was interesting. Here we go. Wait, actually, I just skipped it. I wanted to play that part. Here. It was right here after the sidebar. Oops. Timber. Here we go.
Question. Mr. Alessi, I need you I need you over there. So,
Yep.
and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the cover.
How about it?
Thank you. All right, so you can answer Mr. Alessi's question.
Thank you, Your Honor.
Could you give me the question again, please?
Yes. When did you create the updated presentation that you reviewed in your direct testimony?
So that addition I made was taken out. It wasn't in my direct
Sir,
testimony.
If you can just hear my question, it's this. The version of the presentation that you put on the screen, when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday.
He is off the rails. We all know what he's talking about. The jury knows what he's talking about. He's talking about the major change to his presentation. That he actually took his presentation and changed something in the middle of trial. That's what we're talking about here. We're not talking about headers that you took down, sir. We're talking about the actual change. But he keeps going. He's like, oh, the change. Let me go backwards. The judge told me to change the header, so I did that. He didn't say this part, but like it was almost like he's saying like there was a comma and I put a period, and he's going through all these changes as though Alessi's asking him every keystroke that he did on his computer.
When the judge asked me to take off some of the headers, so yesterday.
Okay, good. Now, the version before that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
So every day.
So you've changed the presentation every day since when?
No, I don't think I've changed the presentation every day.
That's my question.
He just said, I change every day. Oh, no, I don't change it every day.
My question is, how many times have you changed it within the last 2 weeks, your presentation?
Let me try and cut to the chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
You're
here's
welcome.
the question. Your first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Thank you. He just dances around the question and the answer. But we know that Welcher made last-minute changes to his presentation after consulting with prosecution. We already heard this in the questions outside of the jury's presence. Remember that? We know that. The jury doesn't know that yet, but this was the time. These were the questions he was going to ask. And this just raises some questions about the consistency, the reliability of his testimony, which is exactly what Alessi is trying to get at. Okay? He's trying to make him look bad.
Assuming the trial started April 22nd of 2025, you changed your PowerPoint presentation during this trial, correct?
Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago.
The last time I changed it was 10 minutes ago.
So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer so I didn't
No,
interrupt you.
I'm not sure how much granularity you want to that answer.
Great. So you created on January 30th, 2025. You made your
13th.
Pardon me?
Oh, the original one. Sorry,
Yeah.
January 30th, modified May 13th.
Right. If I could finish my question, I might be able to shortcut this. Thank you. So you created the original one on January 30th, 2025. You made your first amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy. When
Something
we're in the
funny about
courtroom,
that,
so
sir?
It was yesterday. How many times had you changed your presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brandon asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then I've modified it a couple times today based on rulings from the judge.
Okay, let's break that down. You said half of the changes you made on May 13th related to what? Because I want to know about the other half.
Sure, there was two changes. I added the extra path of 138, and then I was told that the defense was having problems with my PowerPoint, so I had to go in and add the paths to every single slide about where the evidence came from, because they were saying I didn't provide everything, and I had provided everything.
All right. So
That was the second half.
got it. I want to go to the first half, sir.
Sure.
And I'm going to try to shortcut this.
Please.
And if I'm not clear, you just let me know. I want to talk about the first half. You called it, I didn't hear it. It was like, did you say path?
Path.
P-A-T-H?
Correct. The path Miss Reed was driving.
Right. What you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
Listen to this carefully. He was like, that wasn't because of the defense that you changed it, the path that Karen drove.
It was based upon her statements. Is she part of the defense?
Is she part of the defense? I had to laugh. I mean, he has a point. Karen said things in that documentary that she made, and she said she did a 3-point turn on a certain street, and that made them reevaluate their data. And then they changed, well, he changed his PowerPoint, allegedly. I would like to know exactly what part he changed. But if he was truly trying to be accurate, then maybe when you get more information, it is important that you change it. But it could be to fit a narrative, you see? So that's why it goes to both sides. That's why it's being brought up in the first place. But here's the thing.
All right, so that's what I wanted to get to. You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
It's because I changed one slide. There was 130 slides.
The voir dire. Voir dire. I talked about this yesterday. It's about speaking the truth. It's a French word. I'm probably always going to pronounce things wrong, but Kat asked if I could explain that. And yes, that's basically just to question things that could possibly not be admissible so you can do them outside the presence of the jury so that you know what's going to be allowable instead of having a bunch of objections, because then it can also look bad. So you're kind of testing your witness before they go on.
Slides originally, or something like that. So half of the changes on that day, which was one slide, I added one line to the bottom of the previous slide.
Did you consider that change significant?
No.
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony?
So A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that I gave, the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
So you were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Ms. Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
Right. So that was the point I was trying to get at. That clip existed for months, and he's going to open his computer again.
I don't believe I got it until April.
So a clip that has been, assume the clip's been in existence for months. You just got the clip.
Dr. Welcher, I have to ask you
Oh,
not to
sorry.
refer to
I'm
that
trying to
source.
be helpful.
Close your computer.
Let me
Close your computer. Being admonished by the judge is not a good look. He's like a little kid that can't stop and look at his iPad. But he's going to ask him whether or not he knew about Burgess's submitting a report in the middle of trial, because that also happened. And we're almost done. I do have to go soon. I hate leaving, but I do have to go soon. But let's go to this next part. Actually, I'm just going to tell you this next part and then we can skip ahead because this was interesting. So I want to get to it. But that was pretty much the end. He asked about the changes. We already know they happened, and that he submitted his report like a day before he came to testify. I don't know if you knew that. You probably did because a lot of you are ahead of where I am. But I don't think we need to watch every single clip to discuss everything that happened. But when they're back from lunch, Alessi's still talking about the PowerPoint amendments, and it turns out that he's going to reveal right now the defense only got them Memorial Day, like a holiday, at 3 p.m.
Left talking about the amendments you made to your PowerPoint presentation. And in terms of the amendments, are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
And you began testifying the day after yesterday, correct, sir? Day after Memorial Day?
I testified yesterday.
Yes.
That reminded me of my cousin Vinny when he's like, I shot the clerk. I shot the clerk. And he's like, you're making a confession. He's like, I was here yesterday. Like, I was here yesterday. He was like asking in a very interesting way. We're gonna go ahead. I'm sure all of you know this by now, but here, let's just play this little part. I think this is it. He's going to be talking about all of his certifications. And the reason why he wants to do this is because the next witness, and I kind of alluded to this, he's going to be a certified engineer.
Which topics?
Okay.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain text stream events.
We're getting into the text stream and the EDR data.
Correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is Event Data Recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, Event Data Recorder.
Sounds good.
EDR data does not show the location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a text stream event, correct?
This is really important. This is kind of getting to the end of the day, but at the same time, it's like one of the most important parts.
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
I'm going to break this down. The text stream data from the Lexus, it includes something called a key cycle. I know you've been watching, so you probably know what it is. And then the time within the key cycles, but they're not actual, like absolute timestamps. And the EDR, which is the event data recorder, does not provide direct time or location of these text stream events in this Lexus model. So to analyze the timing and the location, which are both very important in this case, as they are in many, one must accurately associate each text stream event with a correct key cycle and trip. So every time you start your car in this kind of Lexus, there's a new key cycle that's created. And this is so important because of this next line of questioning. So that's why I wanted to clarify. And I also wanted to pull my hair out while I was listening to this because it's a lot. But I think when I explain it and as we go along, you'll be able to understand exactly what it means.
In order to properly determine the location and the timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes, that text stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not determining that, I'm reading that from the text stream data.
Okay, so in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
He thinks that's a fair statement. Let me clarify this again, because as we move along, I want to make sure you get this because it's so important. Every time the car turns on, that's referred to as a new key cycle. And you can think of it as putting your key, like the physical one, we don't have those these days, but a physical one, some people do, inside their car, into the vehicle, and you're turning it. And that entire time that your car is on, that would be one key cycle. And just imagine that after you turn your car off, you take your key out, and that would be that every time you're doing this, You are turning your car off and on and off. You're going through those key cycles. So when you turn it on until you turn it off, that's a key cycle. And then you're actually going somewhere during that key cycle, right? Because that's what your car is for. And that would be considered your trip. So if someone wanted to figure out where you went, what your location was of any of these events that happened on that trip, right? Like say you got in an accident on that trip, they would obviously need to identify the beginning of that trip, which would be the beginning of the key cycle, which would be the key cycle. I hope that's like understandable because I know this can get really dense and confusing. But just listen because it's going to get more interesting.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence.
Sir, what? That's literally like me saying, I want to find out where John was last night, but I'm going to look at his location on Find My iPhone right now. I don't know if this is making sense or if he's just not understanding, but this is what he does for a living. And he's looking confused when I even understand what he's talking about. So that's kind of puzzling and concerning to me. To get the location and the time of an event, you have to correctly identify the trip for that key cycle. Easy. If you're associating the wrong trip with the wrong key cycle, that's going to lead to the wrong conclusion. You would be looking at the wrong data for the wrong event. And there's a reason why the defense wants to make this clear. I know you probably know why, but there's a lot more to understand. So I'm just going to jump ahead. But this is important. There is a theory, I'll just tell you, there is a theory during the last trial that the key cycle that they're analyzing, that the Commonwealth was analyzing, was actually from when the car was in custody already. But we're going to get there. Okay, we're going to get there.
In the text stream, with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So, again, the text stream event tells you the
It's a matter of logic, sir. Like he said, if you're looking at the wrong thing, it's going to be wrong. But Dr. Welcher is going to maintain that the text stream itself links the events and the key cycles, meaning you can't really screw that up. But he does agree, finally, that if you attribute the wrong context, then that could skew the entire interpretation. I mean, I think that's important. But I want to move on to some other evidence that Alessi wants to put forward regarding these key cycles. And the Commonwealth previously had a stance in reference to key cycle 1167, and I think 1162, but I think I might be getting ahead of myself. But we only have a few more left. So let's go there. Here it is.
Thank you, Your Honor. So I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024, yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167?
Correct.
And in this screenshot, we can see 4 text stream events
Actually, can you zoom in on the key cycle?
Yeah,
sure.
I can't see it.
Because I think when I got to, no, scroll. So when I got to it, you can see it was that key cycle 1264.
So down below, if you look at the blue box, the square one in the first column, and then you can see that blue line going across the top, that's one of the 1167s. And then there's another one, another one, another one. So this report is showing 4 key cycles. Okay?
The blue highlight was the last file that was written on key cycle 1167.
Hi, Tiffany.
So to answer your question, I got it at 1264.
So if we can go back so we can see the 4 text stream events, I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that...
Uh-oh.
Are you saying there's no basis for the question?
Yes, eh?
All right, I'm
They
going to
don't
allow
want
the
this.
question and I'll hear it.
You are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
So the objection sustained. You need a foundation, Mr.
They're going to go to sidebar. Okay, they're going to go to sidebar. My dad's from Boston, so I'm allowed to make fun of it. And we know everybody knows we're just being cute. Okay, we're not trying to offend anyone. It's not our intention at all. So we're going to move ahead. We have 3 or 4 clips left. I don't even want to go, but I got to go play Sherlock Holmes so that I can continue to analyze these cases with a sharp mind. But obviously, Alessi was asking whether he knew that the Commonwealth had allegedly had a different time or a key cycle when they thought this trigger event occurred. Okay, there's a sidebar, it goes on for a while, and then they come back.
It's an appropriate question, Mr.
Sure. Do you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor?
You have to remove part of that.
Okay, understood, Your Honor.
Yes,
Do
remove
you
part of that.
know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustained.
I'm going to ask for an instruction.
I'm not giving the instruction now.
Dr. Welcher, in terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
The Commonwealth does not want this out. Yes? Hi. No, I'm almost done. It's okay. It's like I'm not going to the bathroom or anything. And he's like, oh my God. Okay, I'm fine. So the Commonwealth does not want this out because I got to be honest, it's pretty damning, I'd say. Again, all it shows, not all it shows, but it shows changing their hypothesis, changing their theory, changing the times. And what can this go to fit their narrative? So that just doesn't look good. And this is not the first time they've done it. So they go to another sidebar.
I'm going to see you again, folks. I'm
Yeah,
sorry.
they go again. It's really long. They come back, and now we're almost to the end. The prosecution initially alleged that key cycle 1162, I believe it was 1162, could be wrong on that one, occurred at 34 Fairview and involved Karen Reed striking John O'Keefe. That key cycle is the one associated with the 24 mile per hour in reverse. The defense was arguing that that key cycle, compared to the mileage and everything else, aligns with when the Lexus was being loaded onto the tow truck. So I'm telling you something that the jury, I don't think, has been aware of yet, okay? So we're going to just table that because that's what they did, because Judge Cannoni was going to limit how much of that he was allowed to get into, so he's moving on. And now he went into Dr. Welcher's credentials. And there's a reason why. Remember I told you? Because the first defense witness is going to be coming up. It already did, I think, today. I heard part of that testimony. and he's going to be a certified engineer. So at this point, the last thing the defense wants the jury to hear about is Dr. Welcher's credentials. He wants to remind the jury at the very end of what he has compared to what their witness is going to have.
So, do you know what a force calculation?
Oh, I forgot I was going to show you that clip because you don't really need to hear it. He's going to go into this witness's background. It's going to be fresh in the jurors' minds that he holds a degree in. Is it biomedical or biomechanical? I think he holds a degree in biomedical engineering, but he works as a biomechanical engineer. So he does the whole clarifying what he analyzes. But then we're going to be talking about the effects of physical forces on the human body, like things that would happen with Newton's second law of motion. Did y'all take physics? I did. I was excited when I hear this. I don't like math, but it's force equals mass times acceleration. And I remember when I was working in corporate, my boss used to give me such a hard time when I said times instead of multiplied, but okay, I took physics. We said times, but we're going to be talking about how Newton's second law applies to skull injuries. I find this interesting. Maybe you won't. But this goes back to the test dummies that were dropped. Remember that whole experiment? Let's proceed.
Calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I wanted to get to. Newton's second law has been sometimes referred to as the second law of motion. And in the
What is he reaching for? Oh, I know what he's reaching for.
second law is force equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when
What
you're
is that
trying
called
to-
again? TI 83? T something? Yeah, it says graphing calculator.
Sir, you're pulling something out.
Calculator. I thought you were going to ask me numbers, do
He's like, I'm being tested.
calculations.
All right, we're going to do that. We need to do it with the court's permission.
Sorry.
So if you feel you need to do that, just let me know.
You can just leave it right
All
there.
right.
So I just want to get the principles down first. So Newton's second law, force equals mass times acceleration, and force is oftentimes what you're trying to calculate in a force calculation, correct?
Calculate or measure, yeah.
Yeah. And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that.
I was like, Alessi, why are you flexing? Like Newton's first laws of inertia. An object, and we don't need, but he's like flexing that because like, we're not going to talk about that. Then why did you mention it?
In force, we're talking about Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay. And that Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report.
This was interesting. I liked this. Hi, Adrina.
And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches, at that fall, Mr. O'Keefe's head would have accelerated with 458 Gs of force.
That's what we actually measured
Right.
in the test.
And can you tell?
So before we go further, I want to break this down really quick because some people do come here and want the recap because they're trying to think about this and they want to stop and they want to pause and they want to hear it and then they want to understand it. This can be confusing. So he used a test dummy and he dropped these test dummies from 69 inches and he measured 458 Gs of acceleration. Gs, he's going to explain this now.
The jury what is meant by Gs.
So G's is a measure of acceleration. If you usually acceleration is measured in feet per second squared. If you divide it by 1G, which is 32.174 feet per second squared, that gives it to you.
Because we're experiencing 1G of gravity, right? That's what we're experiencing. And then he's going to calculate how many Gs. And that's a measurement of force. And this calculation resulted in 7,200 pounds of force on the head. Got that? Because that's going to be important. Because Alessi is going to challenge this.
In Gs. People often heard about fighter pilots losing consciousness at 6 or 7 Gs, basically because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or Gs as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1 G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
And that 7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand it, you go to the scientific literature, and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry.
Okay, everyone's confused. Probably the court reporter is like, what? Do you remember when he showed that scientific study? Because I saw this right away. What they're going to get to, I noticed this right away, but I didn't say anything because I was like, maybe it doesn't apply. Maybe it's not important. But the scientific literature that he showed said the back of the skull can fracture at an average force of 1,634 pounds from a fall of 40 inches, which means something force at 7,200 pounds, which is way more than 1,634 pounds, would clearly be enough to easily cause a skull fracture. That makes sense. It's easy math, right? 7,200 pounds more than 1,634, which is what the defense is getting at. That Newton's law is not conditional on a situation, because we're going to hear this. Just listen. It's math. It's simple. It's a simple math equation. It doesn't take into account anything else. It's not really what the doctor is saying.
Sorry. 4040? That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds, and then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
Alessi's just saying it wrong. He knows what he's saying, but he's making mistakes. It happens.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated. Surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture your skull.
So I'm not getting at the manner. I'm just applying Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface.
This is interesting to me. It's a mathematical equation. It's plug and play. All you have to know is the mass of an object and the rate that it's accelerating. But let's continue.
A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics.
This is the part that I noticed.
That's in your report, correct?
What reference number?
May I, Your Honor, grab the report? Yes. If you can, it's in your report, sir. If you can find it, I'll do it in parallel with you.
You remember this report? It came up on the screen. I wish I would have gotten the timestamp. Because there's like a gotcha moment here.
Is it number 25?
That's the one I think it is. I just want to check your report.
Would you like me to actually pull up the paper?
No,
Okay.
just want to get to the... That's it, number 25. We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Or could the witness see the document that's being referred to?
Do you have your report in front of you?
I have my report, but reference 25 is not in the section he's referring to.
Why don't you show it to him, Mr. Alessi?
I do not have with me a copy of the report he cites in his reference. He did. Can I ask another question? Your Honor?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries?
He did. And he said, like, over 60% of the cases of motor vehicle collisions with a pedestrian, the head injuries were the most common.
And relate it to heads. Did you not, on your direct, talk about percentages of injuries that are head injuries in impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next
Can I
question.
go to my slide?
Whatever you can use to determine what was the percentage that's in the study
It was like
that you
60%.
cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for
Thank
all
you.
injuries, 12.7 for fatal injuries.
Thank you. So I'll repeat my question, and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
This is important because remember, John O'Keefe's head was impacted, but his lower extremities were not. So he used a study that said 61% of pedestrian motor vehicle collisions result in head injuries. They're the most common. That's important because of the next thing.
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay. So doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony on
I
direct?
thought I did.
This article was published back in 1979, correct?
That's the part. It was from 1979. I noticed this and I was just like, it's probably not a big deal. But I remember him saying this was the first study ever conducted. And I was like, when? Anyway, Alessi argues that there are more recent research, obviously, that shows lower extremity injuries are now more common. And that's because vehicle safety changes that have been made to vehicles.
I believe that's correct.
It's 46 years old, therefore, if I did the math correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. It wouldn't surprise me.
Well, wouldn't you have looked at the studies? That's his point. There are newer studies. In the law, there are cases that set precedents, right? And they can be really, really old. But if a new case just came out, and let's say it goes to the Supreme Court, that is the new precedent that's been set. So you don't look at the older data. You don't look at older citations. You don't look at older references. I mean, I think we all know that it's kind of common sense if something newer came out, you're not going to cite research from 1979. But he did. And he should know that newer research came out because you would need to know that if you weren't trying to look for your own narrative. You would be looking at what's true in these scenarios.
Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or bounce off. to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
Okay, so he's just said a lot. From what I gathered, he is agreeing that vehicles technology has shifted, but what he's noting is that this usually affects front impacts, front end, not rear contact scenarios. And we know it was allegedly a rear part of Karen's car that would have clipped, in their opinion, John O'Keefe. So I'm going to wrap this up. But one of the arguments that Alessi was making is that all this analysis that he did, the force analysis, so everything he just presented about how much force you would need to break a bone and all that, he never did any math equations. He didn't essentially show his work. So he doesn't know how he got that outcome. So anyway, he didn't show it in his direct testimony slide deck. That's what he was saying. He's like, did you even show this? Did you show your work? It's kind of, I don't know if it's a non-point. To me, I think he had a point by saying he knew the concepts.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
No specific numbers, no.
Thank
the general
you.
concept of the drop testing and what it showed, yes.
Cuffy said he didn't do the long division. That was funny. I'm not trying to be funny this whole time, but I find humor in this. But anyway, he communicated that he clarified he got the points right. That falling backwards onto a hard surface could cause the injury. And then he talked about the eye laceration. I'm not going to go into all that. But he then said, you know how he said that the laceration was consistent with hitting the spoiler? He didn't go into the garage. He didn't walk on the lawn where the body was found. He relied on scanned images and street level photos. But he acknowledges not physically reaching the point of rest. And then there was the whole berm debate. I don't know if you remember this, but there was a portion of the side of the road that had like a little 4-inch berm where the body was found. And the defense was arguing that this could undermine the theory about the spoiler. And what he was saying is like he didn't look around for other things that could have caused the injury. But let's go on to this last part.
So instead of that calculation, you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you
Remember that? I think we already did that. I think this is the part.
It was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height, matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that thing or swelling because you don't have information as you just described.
Sure, it could be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe at the time of impact had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
Karen brought up a really good point, Karen, here in the chat. He also did not check the height of the car. Reed's car changes height when it's driving and when it's still in parked. And I saw that from today's testimony, so I didn't want to go forward. But you are right. And the point I was just trying to make is that there are a lot of unknowns here, which is important. Lots of unknowns. But he acknowledges the injury could have come from hitting the ground or another object. But he also maintains that the spoiler theory is just that. It's one possible theory that could have happened. It's not definite. It's not a conclusion. And speaking of conclusions, that is where I was going to end. I wanted to also just point out the pros and cons because I want to be fair. I want to talk about things that I thought could have been good. My Siri's going off. Siri, stop. Sorry. There were definitely pros and cons of the testimony. I think that the pros were that he's an expert in his field. I'll give him that. I mean, I think we can all say he has enough experience to be an expert. He's got a background in biomechanics, he does accident reconstruction, and I think he provided the jury with a really well thought out and well brought out examination of all of his scientific perspectives, right? Even if his slides were a little messy, which we'll get to later, but he did a detailed analysis, right? He had a very comprehensive approach to all this, which included vehicle data. He analyzed physical reconstructions. He wanted to establish plausible scenarios of how the injuries could have occurred. But really, the cons I saw was the potential bias that he could have had, the significant compensation that Aperture got, the timing of the presentation changes. That could mean that, they were looking for one narrative to be true. And then there was the absence of certain injuries like broken bones and the inability to conclusively state that a collision occurred. And that could really weaken the impact of his entire testimony because overall, Dr. Welcher's testimony, it introduced very complex scientific and physics and all these things that are really intended to support the prosecution's case, but it was really effective on cross examination to show the limitations. That influences how the jury is going to perceive his credibility and the relevance of everything he presented. Because if they can't even keep up, that's a problem. And I think when you see the witness from today, which we have one more day until today. So tomorrow I'm going to do yesterday's, and then tomorrow, and then the next day I'm going to do today's because I need a little time because I'm watching these 4 and 5 times to understand it myself. So just imagine the jury. They only have one shot, one opportunity. I always think of the Eminem song, but they have one shot, one opportunity. So I just wanted you to get the pros and cons. I know that I was laughing. I know that these things are funny to us, and I like this group. I love the chat. I wanted to quickly talk about my favorite comments that came in today. Marco said that it looks like both sides are dropping the ball. I think that can be true. I think both sides have done things that are looked at poorly. We haven't seen the defense's case yet. It did start today, so we'll have to see. And Kat said, "Hi, Kimber. I love watching you. This is my first live. I'm watching from Scotland. Not update on the Karen retrial, but know some of the case. Oh, they're not updated on it." And then Laura said, "We need some Kimber merch." I agree. We do have some Dark Liberty merch, but we don't have any. But my style, if you don't already know, like I don't know, like look what I'm wearing. Like I'm wearing this like spray painted shirt that I'm not a morning person. My style is kind of weird, but I'll try to make some cute merch. I'll try. But we also agreed that we're needing the Law Baddies merch. I mean, I would buy that. I don't know if I'm going to get your name right. Themis and Aurora 33. Truth is not subjective. Perspective of what truth is may be subjective, but what is true is true. It exists independent of opinions. I really like that. That should also be on a shirt. And Miranda said, "I just wanted to pop in and say hi. I'm going to rewatch at 4 a.m. when she's up for work." I got my amazing super chats and I thank you so much. And Dr. Angelique said, "I think we should take a shot every time. I think, wait, every time Alessi says, okay, my question to you, sir, was, oh, Alessi, or sir, I think you didn't understand my question. I think I would be completely wasted by now. But I have thoroughly enjoyed talking to you tonight. And I appreciate you being here. This was a long one, but thanks for sticking by me, those that could stay. And anyone watching on the replay, thanks for being here. I really appreciate all of you. And I'm going to see you so soon. Oh, Cecilia said, this is great. So happy I made a live. I just saw a Crime Junkie live tour here in Phoenix. I would fangirl if you did a tour. I want to do a tour. I'm kind of like not agoraphobic or anything like that. Like I'm not afraid to go outside, but I'm afraid of crowds. It took a lot out of me to go on stage at Annie and Lisa's live, but I did it. And I was really proud of myself. But thank you so much. And I said your name perfectly. Thank you. I'm going to see you all very, very soon. And guess what? I have a Didio. I have a Didio coming out this week. I surely do. It's a little late in the making, but I was in a P. Diddy music video back in the day. So I'll get to my experience with that. But I do want to put out a P. Didio. P. Didio. Okay. On that, I'm going to go. Oda Maris, bye. I'm going to have fun playing Sherlock Holmes, and I will see you very soon.